Everyone is settled now? Does everyone have each person has all the different amendments, yeah? Can we begin? The leader of government business, which one? You don't have the Attorney Generals as yet?
Clauses 16 and 17.
The question is that clauses 16 and 17 stand part of the bill.
Yes. May I ask the Honorable Senator Clarence Rambert, in terms of on clause 17, ma'am?
All right, so let's just deal with clause 16 then.
Okay.
Clause 16.
The question is that clause 16 stand part of the bill. The question is that clause 16 now stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. Clause 16 now stands part of the bill.
Clause 17.
The question is that clause 17 stand part of the bill. Senator Mark.
From the Honorable Minister, in clause 17, subsection 2, or subclause 2, we are saying that the TTSC TTSP rather, thank you, which is the Trinidad and Tobago Society of Planners, they would have to issue a certificate of good standing for the renewal of a professional license. I just wanted to ask the Honorable Minister, what will be the role of the Council in this context? Because what we are seeing is that we have two bodies that would be operating side by side. TTSP, and then you have the Council of Urban and Regional Planners. So we are saying that a certificate will come from TTSP, and I'm just asking, why TSSP and not the Council? And as I'm on that, Madam Chair, may I also ask him,
Madam Chairman, it is not really a drafting issue Senator Mark is raising. It's an issue relating to the structure of the bill. And it is very clear that the society has one particular function, which is to represent the interests of the professional members, and the council has an overarching responsibility to manage the profession in relation to the issue of the licenses and the disciplinary functions and so on. So it's two different entities operating, so that the licensing regime, which is administered by the council, part of the licensing regime involves a certificate of good standing by the representatives of the professional members, which is the society. So nothing is unusual about that.
May I also ask, Madam Chair, through you to the Honourable Minister, a certificate of good standing. Do you think that I think earlier on in the bill, if I'm not mistaken, Madam Chair, did these people have to secure a certificate of good character from the Trinidad and Tobago Police Service? You want to clearly air for me on that?
Madam Chair,
Just 1 second. I think Senator Vera has something to add or ask.
Thank you, Chair. So may I take it that if you don't have a certificate of good standing from TTSP, you can't apply for the renewal of the professional license?
the requirement under 17.2 that you have that certificate.
No, I'm comfortable with it. I just want to be clear about it. Yes, thanks.
Senator Marks' question.
You remember,
Right.
I can't recall the exact section, Honourable Minister, but does urban planner who has to secure either temporary, provisional, or professional license, would that person have to secure a certificate of good character from the Trinidad and Tobago Police Service, or that is not applicable to those professionals?
Senator Mark, believe it or not, I'm going to ask you to raise your voice a little bit because some of the senators behind you are not hearing you.
Oh,
So
I'm so sorry. I apologize. Yeah, what I'm simply asking the Honourable Minister is whether a certificate of good character from the Trinidad and Tobago Police Service for one to secure either a temporary.
I know you're asking the minister, but I don't think that that really is relevant to this particular clause. So perhaps the minister,
All right,
Yeah.
well, we could come back to that and so on.
Sure.
Leave that, sir.
Madam Chair, I would say that if we continue to proceed, we've been at it for 5 minutes, and if we continue to proceed in this way, Section 17 addresses the renewal of a professional license, and it's not based on conjecture. It sets out the requirements at sub 2 for the renewal. The issue of conjecture about certificate of good character from the police does not arise. The issue of provisional license does not arise. That is 18. And the issue of a new application does not arise because that is 15. We are dealing with 17, which deals with the requirements for the renewal of a professional license.
so honourable senators, the question is that clause 17 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 17 now stands part of the bill.
Clause 18.
The question is that clause 18 stand part of the bill. There is an amendment circulated by the Attorney General.
There is
Yes?
a very simple amendment to delete at 18.1 in line 4, after the words section 15.3a Roman 3, to delete or 4.
So, honourable senators, the question is that clause 18 be amended as circulated by the Attorney General. Those in favour say aye. Those against say no. I think the ayes have it. The question is that clause 18 as amended now stands part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 18 as amended now stands part of the bill.
Clauses 19 to 24.
The question is that clauses 19 to 24 stand part of the bill.
I don't think we should go that fast. I think we're going nice. 19, 20, and we're going. But go.
The
Because
question is,
have a lot of things to raise.
the question is that clauses 19 to
all right.
24.
May I raise my questions, please?
Yes.
Madam Chair, on the 19.4, asking the Honorable Minister, deputizing for the Attorney General, whether this provision should not be applicable to all license holders. We are only targeting temporary, but we are not looking at what is taking place with those persons who might be getting provisional as well as the permanent persons. So if misrepresentation takes place at another level, would this Section 4 be applied, Madam Chair? So I wanted to indicate to the Minister that they should consider having it as something across the board for the different categories.
Madam Chair, quite frankly, I have no problem with it. It's just a matter of dealing with it in terms of where's the best place to deal with it.
I think the answer is that in this instance, you're dealing with somebody who is not a citizen of Trinidad and Tobago, and so you're canceling ab initio anything that is based on a fraudulent or false information document. If it is a Trinidad and Tobago national, I think the provisions of 55 and 56 kick in, because that would be an offense. So I understand that there's a difference between the foreign applicant and the local applicant.
Minister is looking at that. Madam Chair, I just want to go to 20. Right? Madam Chair, you'll see 20 refer to the first schedule, right? And if you go to the first schedule, the fifth specified in there, like, yeah, the fifth schedule, thank you very much. Yeah, the fifth schedule, ma'am. If you go to the fifth schedule, Minister, you can follow me on this one as well.
Your voice again.
Yeah.
So we're
If you go to the fifth schedule,
yes,
you'll see Form 1,
yes,
Form 2.
yeah.
Form 1 is professional, Form 2 is provisional, and Form 3 is, in fact, temporary. What I wanted to ask the Minister, the tenses, if you read, for instance, what is in Form 1, this certifies that John Harry was. I'm wondering, for instance, if it should be is and not was, because the physical preparation is one thing, but when you get your license to practice, it's another thing. So I'm just wondering here, Honorable Minister, if you look at Forms 1, 2, and 3, you have almost a similar kind of past tense being introduced here. So I was wondering if there's an error there. Why are we using the word was?
Perhaps that can be flagged.
Yeah,
for
Madam Chair, we could
when we
deal.
later are dealing with the schedules, because
Okay,
we
okay,
have to go through the schedules, so that perhaps we can
So
just
we'll
take a
leave that
note
for
and
the
we'll deal
schedule,
with
right?
it then.
Then in 21, I wanted to ask the Honorable Minister, in 21, if someone fails to display conspicuously their license, is there a sanction for not displaying? because I can't recall seeing a sanction for that. So I need to get some clarification on that. And Madam Chair, you're going to 22 as well?
No?
You went to 22?
No. Okay, I thought you wanted to respond to that question, Senator Mark.
You're not hearing me. All right, let me just repeat.
So, all right, let me just repeat for clause 21. Senator Mark is asking whether there is any penalty for not displaying the license as set out in clause 21.
I'm just trying to get some clarification here, ma'am. And then, if I may...
No, well, I think we have to give the minister an opportunity.
Okay.
Madam Chair, can we stand that one down? I'm going purely on recollection that there was in fact a provision, but the CPC is looking for it. And
21 is stood down, so let us just deal with, no, just 1 second, clauses 19 and 20. So the question is that clauses 9,
Clauses 19 and 20.
the question is that clauses 19 and 20 stand part of the bill. The question is that clauses 19 and 20 now stand part of the bill. Those in favor say aye. Those against say no. Clauses 19 and 20 now stand part of the bill. Clause 21 is deferred.
Clause 21.
That is deferred.
Clause 20.
20.
Clauses 22 to 24.
The question is that clauses 22 to 24 stand part of the bill.
Madam Chair, I think it is important for us to clarify in law, and we cannot be vague in this matter. I'm dealing with clause 22A. What is meant by reasonable remuneration? We need to have a definition or get some other form of wording, Madam President, because how it is stated here, it is extremely vague. There are no guidelines as to what constitute, or would it be in the regulations, Madam Chair? I don't know. But I just found that to say reasonably or reasonable remuneration, what does that mean? So I'm just trying to get clarification. And then when you go to 23, you have in section 23(1) reasonable charges for professional fees. Madam Chair, we have to have a schedule or guidelines so that when you go to an urban planner or regional planner, someone can interpret this in one way, and then they charge you, and you go by somebody else and another charge. So it's either we leave this out and let market forces determine this thing, or why are we including something that may not work, Madam Chair? It doesn't make sense. So I'm just asking the Minister
sure.
to
Senator
clear
Mark,
the air.
Minister.
Madam Chair, this is the normal springboard that you would use in legislation. It is the question of reasonableness is an objective test, and Senator Mark is right. It could be supported by regulations. It could be supported by a scale of fees in regulations. It could be supported by a schedule. But this is the springboard for doing that. And what Senator Mark proposes of having it removed altogether is far more dangerous than what is in the bill now, because then you, as he says, market forces, there isn't going to be any guidelines. So reasonable remuneration is sufficient as an objective test to determine what should or should not be included in a demand for payment. And it could be supplemented later on by regulations or a schedule of fees and charges.
Or you're thinking it could be?
It could be. In other legislation dealing with the regulation of professionals, there is guidelines. Even in the legal profession, there are guidelines, and from time to time they are reviewed in terms of what is happening in the market.
But would you say, Honorable Minister, through the Chair, would those guidelines find their way in the regulations so that at least those urban and regional planners would have a signpost or a guidepost?
I believe they would find their way once the council is constituted and the regulatory framework is established. Then this, in the normal way, will come from the professionals themselves.
So, Honorable Senators, the question is that clauses 22 to 25, 22 to 24 now stand part of the bill. Those in favor say aye. Those against say no. I think the question is that clauses 22 to 24 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 22 to 24 now stand part of the bill. 25. 50, 25, and 8.
Clause 25.
The question is that clause 25 stand part of the bill? Yes.
We don't have an amendment at this time, but clarification.
We don't have any amendments.
Yeah.
I'll know when the amendments are coming
Yes,
up.
thank you. I would like to ask, through you, to the Honorable Minister, in 25 subclause 2, Madam Chair, a person's license is suspended, but the council takes its time to make a decision with respect to the revocation of the license. Madam Chair, I'm trying to get from the Honorable Minister, should we not stipulate a time frame for some decision? Because you're dealing with people's property, right? My property is my profession, and I have to practice out there. You're taking a decision to suspend my license, so therefore I am being denied the opportunity to earn an income. Therefore, it cannot be open-ended, Madam Chair. And what I'm seeing here in 25.2 is an open-ended arrangement because there's no specific time frame as to when this council will take a decision on this matter. So I'm just asking if this could be looked at so that there'll be justice in this exercise.
Madam President, there's a process that is set out later in the bill, and maybe as we get to that point, a process for dealing with disciplinary matters, and that process stipulates time frames which would be applicable to this particular matter. So I don't agree that it's an open-ended. There are timelines set out in the disciplinary process.
Senator Vera.
And I would also point out that under Section 27, a person can make an appeal where his license has been suspended to the Environmental Commission. So there is a process in the event you felt that you were being unjustly treated.
Just the question is that clause 25 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes. The question is that clause 25 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 25 now stands part of the bill.
Clause 26.
The question is that clause 26 stand part of the bill. The question is that clause 26 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 26 now stands part of the bill. That clause 27 stand part of the bill. Minister, there is a proposed amendment.
That is proposed, and it's a simple amendment. The first thing is to include in the matters which may be appealed to the Environmental Commission, to include matters under section 16, and secondly, to remove the reference to 18.2, to remove the restrictive nature, so it's now going to be a reference to 18 in its entirety, and likewise to remove the restriction of having 19.2, and it's now going to be 19 in its entirety. So matters for appeal to the Environmental Commission may be in respect of the refusal to renew the license under sections 16, 17, 18, and 19.
Senator Mark?
Chair, I have no problem with what is being proposed. I want to advise the Honourable Minister that in the absence of a 3/5 majority in this legislation, you are restricting a person's right to go immediately to the Court of Appeal. You are saying that that person can only go if he's aggrieved on a point of law. That is like the industrial court. You can only go beyond the industrial court on a point of law. But those pieces of legislation,
What you're saying is not relevant to this section and to this clause and to the amendment as proposed.
no,
So,
this,
honourable senators, the question is that clause yes, Senator Hussain.
Yeah.
This clause, you just told me that you have no problem with the. Hold on, Senator Mark. We need to get a little order in the committee. So there's an amendment proposed. You indicated in your preliminary words that you have no problem with that, but you're now going on to talk about a 3/5 majority, which will not form part of this.
I think, I don't know why we...
Let me hear Senator Hussain, who has asked, and perhaps you can formulate what it is you want to put forward to the committee. Senator Hussain.
Madam President, thank you very much. What I wanted to find out is that why it is that we're asking for the Environmental Commission to have jurisdiction over appeals for the various refusals, revocation, or suspension of the license. The Environmental Commission, in my view, is not an independent body per se. When you look at the modes of appointment of the persons there, why don't we give the persons who are grieved access to independent judicial office, so thereby they may feel more satisfied in terms of an outcome regarding their grievances with the the Society of Planners.
Madam Chair, I'll say two things. The first is that the provision for the appeal does not include an ouster of any other jurisdiction of the court. So an aggrieved party will still have recourse to other parts of the judicial system. That's the first thing. And secondly, we've used this formulation of going to the Environmental Commission in the amendment to the Facilitation of Development legislation. And the government's position is that it affords an aggrieved party an opportunity to have a decision reviewed. And I do not agree with the submission made by Senator Hussain.
Senator Hussain.
Thank you very much, Madam President. I don't know if the Minister will consider, in this light, that it may very well be difficult for someone to access the court. Because if the Commission makes a decision, thereby you now have the only way to access the court is through a judicial review application. Now, the difficulty with that, Minister, is the fact that that person will have to now seek leave, and then there will be a substantive hearing of the matter. Why it is we don't just bypass the Environmental Commission and substitute it for the High Court per se, or the Court of, well, not the Court, well, the High Court, I would say. I think that is the best option that is available to us, because in other pieces of legislation, when there are instances like this, you would see that there's a provision whereby a person has direct access to the court without the fact that they have to seek leave. So,
Yes, in the Dental Profession Act, if I could read it, a person aggrieved by the refusal of the council to register or enroll him, as the case may be, or by the removal of his name from the register roll, or by his suspension from practicing dentistry, may within 3 months after the date on which notice is given them by the council of such refusal, removal or suspension, appeal against the council's decision to a judge in chambers, and the judge shall give such direction in the manner as he thinks proper, including a direction as a cause. Now, what you've done is you've substituted judge in chambers for the Environmental Commission. I know the Environmental Commission is a superior court of record in its own right, and I could see there's a link between some of the work being done by the planners and the commission, but I agree with my friend Senator Hussain that people have been accustomed treating with the court, you know, and maybe there's a particular reason why we want the Environmental Commission to be that decision maker, but it doesn't really come across in the legislation.
Just one second.
I would like the Honourable Minister to also look at Section 29 of the Medical Profession Act, or the Medical Board Act. Again, same point that Senator Vera is making. If somebody's aggrieved, they go straight to a judge. And if they are dissatisfied, they can go directly to the Court of Appeal. What we are doing is creating a kind of some obstacles, which, as I'm saying, because it does not have a special constitutional majority, you may be clashing with sections 4 and 5 as it relates to rights. So I'm just saying to you, you should revisit this Environmental Commission concept that is in this legislation.
Minister.
Madam Chair, as I've indicated, this provision in 27 is to create consistency, as Senator Vera properly pointed out. There's a logic in it, and for that reason, when we made the amendment to the Planning and Facilitation of Development legislation, we included the Environmental Commission as a place for appeals from decisions made by the planning body. And part of the reason has to do with the composition of the Environmental Commission. The Environmental Commission has as its chair and deputy chair lawyers, but the Environmental Commission is also constituted by professionals who are in a position to provide input on a decision in relation to matters of planning. And in the same breath, for consistency, the government has included the Environmental Commission, so we are consistent across the legislation, and we do that because we recognize that unlike a judge in chamber or the other things which are proposed, the Environmental Commission is constituted in a way that it will give decisions taking into consideration the professional expertise of members of the Commission.
I think enough has been said of all this. I mean, you have raised the issue, Senator Hussain, Senator Vera, and the minister has answered. I don't think that there's anything else that can be said on this matter. Just one final point, Senator Mark, please, on this particular clause, yes?
Honourable Minister, through the chair, the people who appoints the members of the Environmental Commission, is it the Judicial and Legal Services Commission, or is it the Cabinet?
Madam President, Madam Chair, Senator Mark is sending me into a realm
I'm asking a question. That's a short question.
Is Senator Mark proposing a particular amendment to 27, Madam Chair?
No, Madam Chair, all I'm trying to do with this piece of legislation is ensure that we do not end up in the courts. And I'm saying that this provision is clashing with 4 and 5. And I'm just
I
saying
don't
that
think you can rehash what you have said previously, so I shall now put the question. Honourable Senators, the question is that clause 27 be amended as circulated by the Attorney General. Those in favour say aye. Those against say no. I think the ayes have it. The question is that clause 27 as amended now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 27 as amended now stands part of the bill.
Clause 28.
The question is, the clause 28 stand part of the bill? Senator Hussain?
With respect to this particular clause, Madam President, the right to make, the power to make rules of court of the Commission. What I'm saying, Madam President, is that are these rules already prepared? Because under the Act itself, there are certain guidelines, for example, appeals from the authority, which is the Environmental Management Authority, which is specific to those matters that are contemplated under the EMA Act, the Environmental Management Act. With respect to appeals that now lie from this particular legislation, are those rules formulated or have been drafted, or what do we contemplate with these rules? What will be the time for appeal to lie? Whether the Commission will have the power to grant an extension, because it's a statutory right of appeal we're giving, and the Environmental Commission is a statutory body which must act within the ambits of the powers given to it by the statute.
Madam Chair, 28 represents, as I've said before, it's a standard springboard. The provision is made there. It is set out that the appeals may be heard in such manner and as may be prescribed by the Environmental Commission. And clearly the intention is that that commission will develop rules of court which are applicable to appeals to be heard in accordance with this piece of legislation.
Madam President, if I may, when I look at the power of the Commission to make rules, I look at Section 8415 of the Environmental Management Act, and those rules that the Commission makes has to get the approval of the President, which is read in this context as a cabinet. Now, this can impact on a person's right to a fair hearing. If we have the executive that is making rules for an appeal with respect to a judicial power being exercised by the Commission. So I'm looking here right now at the right to a fair hearing and whether or not this would be an independent judicial body that will be hearing these statutory appeals.
Minister?
Madam.
Thank you, Chair. I was looking through the Environmental Management Act, and which has the Environmental Commission rules at the back of the Act. But the point I want to develop is what Senator Hussain has said. When you look at Part 8 of the Environmental Management Act, the establishment and jurisdiction of the Environmental Commission, it's very specific. A tribunal to be known as the Environmental Commission is hereby established for the purpose of exercising its jurisdiction conferred upon it by this Act or by any other written law. So what I'm going to suggest is that you may need to amend the Environmental Management Act, because the jurisdiction of the Commission is spelled out at 81(5), and it does not include this. So if it is you're going that route, you're going to need to do some tightening up. They will.
Minister, are you in a position to respond?
Madam Chair, but I was waiting to see if Senator Mark was adding something to what Senator Vieira said in relation to that. Madam Chair, the provision in the EMA legislation makes provision for the jurisdiction of the Environmental Commission in accordance with the EMA legislation, but also provides for the expansion of that jurisdiction by any other legislation. And this is parent legislation, and this fits into that provision under the EMA Act, which allows for the expansion of the jurisdiction of the powers of the Environmental Commission.
So, Honourable Senators, the question is that clause 28 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 28 now stands part of the bill.
Clauses 29 to 31.
Question is that clauses 29 to 31 stand part of the bill. The question is that clauses 29 to 31 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 29 to 31 now stand part of the bill.
Clauses 32 and 33.
The question is that clauses 32 and 33 stand part of the bill. The question is that clauses 32 and 33 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 32 and 33 now stand part of the bill.
Clauses 34 and 35.
The question is that clauses 34 and 35 stand part of the bill. Yes, Senator Ma.
Can I raise under section 34, Madam Chair? There's no mention under 34. How will these members of the recognition committee be remunerated? I'm not seeing any section there. In the case of the Legal Profession Act, there is provision. In the case of the Medical Board Act, there is provision. But in this instance, I'm not seeing any provision as to how these persons who are going to be functioning will be remunerated. So I don't know if the Minister could clear the air for us on that. And I think, okay. Madam Chair, it is contingent to the submission I made, and although it is coming ahead, you'll realize that in clause 59, even though it is ahead, you have a similar situation occurring.
Remuneration, if there is to be remuneration, would be a matter that would be handled by the council administratively.
How? How are they going to have it?
Error.
Usually when you have professions and you have these committees, they're done on a voluntary basis as a way of policing your own profession. It's not done for remuneration. So,
Honourable Senators, the question is that clauses 34 and 35 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 34 and 35 now stand part of the bill.
Clause 36.
The question is that clause 36 stand part of the bill. Senator Thompson-Aye, I believe that there is an amendment circulated by you.
Madam Chair, I have observed that the Attorney General has in fact, adopted my amendment. And in light of the practice that I've learned over the last few days, I will withdraw in favor of the Attorney General.
Thank you very much, Senator Thompson-Aye. Honorable Senators, the question is, I'm going to put this, the amendment as circulated by the Attorney General. We still have to talk on it. I dealt with Senator Thompson-Aye's amendment. She has withdrawn. I'm now going to proceed with the Attorney General's amendment, and then there'll be the discussion. Minister?
Madam Chair, in light of the proposal made by Senator Thompson-Aye, which has been accepted, all we've done in what we've proposed for 36.3 is to use the standard language used in other legislation, so that after the word years in 36.3, we propose to add the words and shall be eligible for reappointment.
Senator Mark?
I just wanted to ask the Minister, given the fact that there's a limited number of urban and regional planners, would you be considering the reappointment of members on the committees in question? Because I'm not seeing any reappointment. In other words, you're going to be there for 3 years, not exceeding 3 years, and that's it. But would they be subject to reappointment, given the limited?
Isn't that the amendment,
That is
Senator
the
Mark?
amendment.
The
Who's
wording
that?
of the amendment
Whose
is to
amendment?
insert the words and shall be eligible for reappointment. Is that,
That's whose appointment?
sorry,
Whose amendment?
the Attorney General?
Okay, I didn't.
That's what we're dealing with now,
Okay.
36.3. So, Honorable Senators, the question, Senator Hussain.
Thank you very much, Madam Chair. With respect to subclause 2, which deals with the composition of the members of the Recognition Committee, I know that we're restricting the number of persons who are council members to form part of this committee. Now, at A, it says 1 member of the council, and B, 4 members who are, and they spelled out the professional members, and those are nominated. Now, I want to ask whether or not we should tighten it up at B to say 4 other persons who are not members of the council, because if the TTSP nominates someone who is the council, they can in fact form part of the committee. So maybe we should create an exclusion there at B, just to say that those members don't form part of the council.
Madam Chair, the view is that we do not wish to put in something that is so prescriptive and leave it for the council in its discretion to deal with the appointments, so that there'll be the appropriate balance. But we don't believe that we should be so prescriptive as the senator proposes.
So, Honorable Senators, the question is that clause 36 be amended as circulated. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 36 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 36 as amended now stands part of the bill.
Clauses 37 to 40.
Question is that clauses 37 to 40 now stand part of the bill. The question is that clauses 37 to 40 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 37 to 40 now stand part of the bill.
Clauses 41 to 43.
The question is that clauses 41 to 43 stand part of the bill. The question is that clauses 41 to 43 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 41 to 43 now stand part of the bill.
Clause 44.
The question is that clause 44 stand part of the bill. Minister.
Madam Chair, there's a proposal to add, well, to do three things. To renumber the proposed section 44 as 44.1, to insert after 44.1 a new 44.2, and that new 44.2 would read, the members of the disciplinary committee shall hold office for a term not exceeding 3 years, and we've added to that language that we just used, and shall be eligible for reappointment.
Before I deal with the amendment as circulated by the Attorney General, Senator Thomas-Nai, you also have an amendment.
The position is the same. I withdraw in favor of the Attorney General going forward with his recommendation.
Thank you very much. Honourable Senators, the question is that clause 44 be amended as circulated by the Attorney General. Those in favour say aye. Those against say no. I think the ayes have it. The question is that clause 44 as amended now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 44 as amended now stands part of the bill.
Clause 45.
The question is that clause 45 stand part of the bill. The question is that clause 45 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 45 now stands part of the bill.
Clause 46.
The question is that clause 46 stand part of the bill. Senator Thomas-Nai, there is an amendment circulated on your behalf.
46. I just was adding, upon proof being received of the matters listed herein, shall remove, and just at the top there. So instead of it being discretionary, I feel that in these circumstances, that the council should remove. I believe we had a discussion earlier, and the Attorney General had explained that he didn't want to put shall, but wanted it to remain like that because of some reason. You all may recall?
Chair, that remains the position. The proposed amendment, apart from removing the discretion, also includes the language upon proof being received. Mm-hmm. Now, it necessarily follows, based on what is set out at 46A to D, that there is a requirement that the matters set out at A to D be substantiated. But the key to it is that the substitution of the word may for shall changes things, and our position is that we wish that it remain a discretionary power of the council.
Senator Thomas-Nai.
Well, that is my view, that because of these things, the reasons that they are very strong reasons for removal of a member of the disciplinary committee, because the disciplinary committee is actually disciplining other people, and therefore, like Caesar's wife should be above reproach. And it's in those circumstances I made that recommendation.
So, Honourable Senators, the question is that clause 46 be amended as circulated by Senator Thompson-Aye. Those in favour say aye. Those against say no. I think the noes have it. The amendment as circulated by Senator Thompson-Aye is not accepted. Honourable Senators, the question is that clause 46 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 46 now stands part of the bill.
Clauses 47 to 49.
The question is that clauses 47 to 49 stand part of the bill. The question is that clauses 47 to 49 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 47 to 49 now stand part of the bill. Just deal with 150.
Clause 50.
The question is that clause 50 stand part of the bill.
Senator Mark earlier referred to Clause 21, which requires the display of the license, and asked about the consequences. And at 58, Clause 58, there is a provision that deals with professional misconduct. And what we propose to do to deal with what has been raised by Senator Mark is to include, after the word breaches in 51, to include a reference to Section 21 by adding the words Section 21 or, so that a breach of Section 21 would constitute professional misconduct for which there are consequences set out at Clause 58.
The words
After the word breaches, add the word Section 21 or.
Or and.
Or.
Or. So it will read an urban and regional planner who breaches Section 21 or Part 2, 3, 4, or 6?
Or 6, yes.
Okay.
Yes, Madam Chair. And I thank Senator Mark for his observation.
So, Honourable Senators, the question is that Clause 50 be amended as follows at 50 sub 1 to include the words Section 21 or after the word breaches. Those in favor say aye. Those against say no. I think the ayes have it. The Honourable Senators, the question is that Clause 50 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 50 as amended now stands part of the bill. Minister, Senator Mark, can we return to Clause 21, which had been deferred? Remember, Senator Mark, it was deferred for the very reason that Clause 50 has now been amended. Yes?
Clause 21.
The question is that Clause 21 stand part of the bill. The question is that Clause 21 now stands part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 21 now stand part of the bill.
Clause 51 and 52.
51.
Clause 51.
The question is that Clause 51 stand part of the bill. The question is that Clause 51 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 51 now stands part of the bill.
Clause 52.
Question is that Clause 52 stand part of the bill. Senator Thompson-Aye, there is an amendment circulated on your behalf.
Yes, Madam Chair. My intention was to both strengthen and widen the ambit of the authority of a disciplinary committee. As it here again, the disciplinary committee is merely making findings and recommendations. And I was drawing a parallel with the Law Association, where the disciplinary committee actually makes decisions with respect to complaints brought before it. Here it is just you recommend to the council, and then the council has to do what it has to do. Now, A, B, C, D, those are the powers that, those are the recommendations that can be made. And E, F, G, these are new powers that I'm recommending be included so that there is a wider ambit of the decision that can be made. Imposition of a fine, and ordering the planner or his firm to pay any party to the hearing or other person as restitution that amount of loss caused by that person's negligence. Or it should be order here, the planner or his firm to pay to the council or to any party to the hearing any costs of or incidental to the proceedings. So that would be in addition to dismissing the complaint, revoking a license, and suspending the license, and reprimanding, which are in fact recommendations that can be made to the council. And so that the first four are what is existing already. Then we go on, the disciplinary committee shall provide written reasons when it makes a decision under subsection 1, and where it's decided to suspend the license of an urban and regional planner, to revoke the license or remove the name of the urban and regional planner from the register, it shall publish a decision. That is the already. So it's just repeated there in 52.
Minister.
Chairman, I thank Senator Ai for her recommendation. Madam Chair, when you look at what is proposed, as Senator Ai has correctly pointed out, what is proposed is, firstly, an amalgamation of 52.1 and 52.2, so that what is proposed repeats A to D in 52.2 A to D. That's the first thing I would say. The second thing is, as she's correctly pointed out, E, F, and G are new. And the matter of disciplinary action, consequences, and penalties is addressed elsewhere in the bill. So I would point out that it is the council that makes the decisions, and there is a structure set out from 52 onwards in relation to the work of the committee and the work of the council thereafter, and the powers, and it's detailed there. In addition to which, at 58, there's a provision in relation to professional misconduct, and we've just at 50 looked at the provision relating to what constitutes professional misconduct, and we've added clause 21, so that under 58, the council may, in addition to penalties prescribed in the regulation, impose a fine of $10,000, so that the regulations, when they're made, may deal with penalties in respect of other breaches which are not currently covered, and may prescribe the process for doing that. And then the third point I would make is that the council has the power to revoke a license, so that is the ultimate consequence of professional misconduct or some breach of the provisions of the legislation. And in our view, what is proposed in 52, what is proposed is in large measure covered in the bill at this time.
Vera.
Honourable Minister, the idea of sanctions when council is going to impose some sort of sentence, the goal is really to maintain standards and professional confidence. I notice that there's a trend now amongst regulators to widen the range of sentencing options. So, for example, to refund money. Because right now you only have dismiss the complaint, revoke the license, suspend or reprimand. But they may the client may just want to get a refund of the money. What happens if the person has a drug problem or a psychiatric problem? Whether or not you may want to have the person order them to take counseling or seek care, medical attention, or what about continuing education? or prescribe some sort of corrective action in order to stay on the register. These are some of the new trends for regulators, and I'm just throwing it out for consideration.
Senator Mark.
I just want to follow up on what Senator Vieira said, and to ask the minister in 52 subclause 2B, we are talking about revoking the license, and are we talking at the same time here, based on what Senator Vieira said, removing the name of the urban and regional planner from the register? So you're not only revoking the license, like in your legal profession, when they revoke your thing, they remove you from the register, the role at the same time. So you can't practice. But so I'm just asking whether in this particular clause, 52(2)B, we are seeking to not only revoke, but remove the name of the urban and regional planner from the register. Because that's a modern way of dealing with things now, when you're with professionals. So I just wanted to ask him, Madam President, Chairman, through you, whether that was the thinking of the government when they were making this rule.
Minister, I think some senators are having some difficulty hearing you as well.
Oh, Madam Chair, Senator Mark has said so many things there. I'm a bit confused because I'm not sure if I'm going to deal with the clause as it's written. So Senator Mark is referring to 52(2), and that deals with the recommendation of the disciplinary committee. And the disciplinary committee may recommend the revocation of a license and removal from the register. Similarly, at 53(3), the council may make that decision. And I'm understanding Senator Mark, and I may be misunderstanding him, but I'm understanding him to say that this is the modern way of doing it, revoking and removing. And that is what is both in...
But some here, so I was just trying to see if I could tighten it and make it more elegant.
No, it is not cumbersome because the keeping of the register, this ties back to 29. The register, under 29, there's a register kept of persons who are licensed. Mm-hmm. So it follows that if you're revoking the license, then the authority to have the name on the register no longer exists. Mm-hmm. So it follows. So it's not two separate decisions that you make to revoke and then you make a decision on removal. It follows that registration being in the register under 29 requires the license. And if the license is revoked pursuant to a recommendation, then it follows.
Vera.
And just to point out to Senator Mark that this is typical in a number of other professional statutes. For example, in the dental profession, if you're found guilty, you could censure, reprimand, suspend, or cause the name of that person to be removed from the register or roll, as the case may be. So it's not unusual.
So, Minister, with respect to Senator Thompson I's proposed amendment, have you responded?
Madam Chair, yes, I've responded to say that we would not accept the proposed amendment in the form set out. We believe that what is asked for is in large measure provided for. There are some aspects that may be introduced, and some of the suggestions made by other senators may be introduced via regulations, because in some way, as I mentioned earlier, this has to be driven. The work of this legislation has to be driven by the planners themselves. So we would not accept the proposed amendment, but we have in fact proposed an amendment which deals with one aspect of what Senator Ai has included in her amendment, and the government proposes to insert after the words at 52.1. To complete 52.1, we propose at the end, after the word recommendations, to include the words together with a record of the proceedings, which may be in writing or in electronic form.
Senators, the question is that clause 52 be amended as circulated by Senator Thompson, IE. Those in favor say aye. Those against say no. The amendment has not been accepted. The question is that clause 52 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 52, as amended, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 52, as amended, now stands part of the bill.
Clause 53.
The question is that clause 53 stand part of the bill. There is an amendment circulated by Senator Thompson, IE, and one circulated by Senator Mark. Senator Thompson, IE.
I was merely making a recommendation for an appeal to lie to the High Court from any decision of the disciplinary committee, but really it is really a decision of the council, perhaps because it's the council that finally makes the decision and the disciplinary committee just makes a recommendation. Perhaps the minister may guide there. Thank you for clause 52, which really was a recommendation in my paper that I had not picked up and which you have picked up and refined. So thank you for that.
Right, Madam Chair, I'm just clarifying that in listening to Senator Thompson, IE, the proposal the appeal is in respect of a decision of the council. Are you amending your amendment?
Pardon me?
What you propose as in clause 53?
No. I had finished talking on that. What I'm saying, the one that you accepted before, in respect of the other one, is one that I had recommended, but I didn't put it in. So I was thanking you for putting it in. But
Right.
in my substantive presentation, I had recommended that, so that was fine with me. So 53, I'm just waiting to hear what you want to say on that.
Right, and my question, Madam Chair, in relation to what is proposed as Senator Thompson IE's amendment, I'm asking, I heard Senator Thompson IE refer to a decision of the disciplinary committee. Now 53.3 deals with decisions of the council. It is the council that makes a decision in 53.3.
Which I said just now, that it is the council.
Having decided that we were not accepting the proposal in 52 to amend 52, then we're not prepared to include the provision for an appeal to the High Court from the decision of the committee or the council.
Senator Choate.
I don't know if you understood.
Thank you, Madam Chairman. I just have a question. We have been looking at this piece of legislation for so long that it may be that I have overlooked it. But there's nothing in the legislation which prevents a person from accessing the courts.
No.
So someone still has that entitlement and has the entitlement to appeal and so on. Am I correct?
Yes, and I made the point earlier when we dealt with, when we looked at 27, that
Thank
there is
you.
no ouster of jurisdiction.
So, Honorable Senators, the question is that Clause 53 be amended as circulated by Senator Thompson, I. Those in favor say aye. Those against say no. The amendment has not been accepted. Senator Mark, you have an amendment
That is to, which one, ma'am?
to Clause 53.
Yeah, I'm asking the Honorable Minister to look at clause 53(2)B. We are asking that you revoke the license or remove, or are we saying that once you revoke the license, it should be removed? So instead of using the word or, we use the word and.
Madam Chair, I thank Senator Mark for his observation again, and we accept what he's recommended to, in dealing with 53(3) to B,
Yes.
to replace the word or with the word and.
Accepting the
We
amendment.
accept that.
So, Honorable Senator Vera,
We are on 53.
3, dealing specifically with the amendment proposed by Senator Mark, which treats with 53(3).
I'll come back to 54. Thank you, Chair.
So, Honorable Senators, the question is that Clause 53 be amended as circulated by Senator Mark. Those in favor say aye. Those against say no. I think the ayes have it. The amendment is accepted. The question is that Clause 53, as amended, now stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. Clause 53, as amended, now stands part of the bill.
Clause 54.
Question is that Clause 54 stand part of the bill. Senator Vera, this is what you wanted to ask a question on?
Thank you. This is general to 54, 55, and 56. These are summary offenses. So generally in a summary offense, you have a 6-month window within which to bring your complaint. Now, so for example, in 55 and 56, you may not learn of the offense until much later on. So I'm just wondering whether you may want to amend to say, upon knowledge of the commission of the offense or whatever. So just drawing that to your attention, because the 6-month entry could be a debar to bringing prosecution.
Madam Chair, we appreciate the concern, and we believe that it may create more problems for us if we interfere with the language as we have it now. It may be something that the Honorable AG would have another look at. The issue is consistency across various similar legislation. We have a wide range of legislation that creates summary offenses, and the CPC does not advise that we make that change. Senator.
I was just going to say it would be a simple line, because like in the Copyright Act, they have after the commission of the offense or 1 year after the discovery thereof, whichever date last occurs. So you could just put, because I'm thinking about the discovery aspect.
He seems persuaded by the language suggested, so we're dealing here with 3 offenses, so
54, which is the one
54,
we're
yeah.
dealing with, and then we'll be able to work out the others, if anything.
Madam Chair, we propose to amend 54 to have what is there now as 54.1 and to add sub 2, which would have the language proposed by Senator Vera. Perhaps Senator Vera could read the provision from the Copyright Act for us again.
Certainly, I'm thinking it might have been easier to just do a separate provision instead of doing it with each of the sections. But what it says in the Copyright Act is no prosecution for an offense under this act shall be commenced after the expiration of 5 years after the commission of the offense or 1 year after the discovery thereof, whatever date last occurs.
Yeah, better come as a... Madam Chair, yes, the CPC is a slow writer.
All of us, because I
But,
actually, yeah.
but no, the bigger issue is
Where should it go?
where should it go? I think we recognize that we need to have it standalone after the 3 offenses, but we just need to be sure that how we deal with other offenses that may have been created in the bill. So the CPC just needs to check that.
May I respectfully suggest, because Senator Vera tends to read very quickly, if he can just write it down and pass it across,
Yeah.
Madam Chairman?
Best is that we defer
Yeah.
clauses 54 to 54, 55, 56.
56, yeah.
57 as well,
Yeah.
yeah? And we will defer those, and when the particular language is, you're comfortable with it, we'll come back to it.
Thank you,
Okay?
Madam Chair.
So clauses 54, 55, 56, and 57 are deferred for further consideration. Okay.
Clause 58.
The question is that clause 58 stand part of the bill.
The ultimate line, planner. Could we have a comma there, please?
With what Senator Thompson
Before
is saying,
equine.
Minister, 58 is also an offense, so do you want that deferred as well? So perhaps we can defer all of part 7?
No, 58 is not allowed. Yeah, I think we could deal with 58, Madam Chair.
Sure. Senator Thompson-Aye, what, you had a question for the minister? For 58, clause 58, you just raised something.
Oh, yes, I said it in the penultimate line, urban and regional planner. If you could put a comma there, please, to separate from the penalty.
Madam Chair, the CPC has assured me that that would be picked up in the final edit and it would be addressed.
I'm not hearing up here. You're not hearing.
Your proposal, the CPC has said that things like what you have proposed would be picked up in the final edit. So he believes that what you have proposed is acceptable.
It will be picked up.
Just the question is that clause 58 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 58 now stands part of the bill. Clauses.
Clauses 59 and 60.
The question is that clauses 59 and 60 stand part of the bill. Senator Diana-Ryan.
Thank you, Madam Chair. My comment is with respect to clause 59. Now, it is built on Senator Vera's earlier observation in terms of the functions performed by the members of the council are usually on a contributory basis, on a voluntary basis. However, subsection 2 of clause 59 draws reference to staff of the council and says that they shall be paid such remuneration and be appointed on such other terms and conditions as the council may determine. So my question is, Madam Chair, is in the event that the council needs to hire a consultant to perform any duties and functions on behalf of the council, where would the financial resources come to pay these consultants? Because nowhere in the bill drew reference to the financial resources and allocation of financial resources for the council.
Madam Chair, the earlier reference, of course, dealt with members of the Recognition Committee and the Disciplinary Committee. There is in the bill the provision to charge fees, and it's a provision that we'd come to based on an amendment that has been proposed. So there is a revenue element of the council, and in addition to which the council may, in the discretion of the Minister of Finance, may also receive a subvention in order to carry out its work, like some other professional organizations do get in the country, so that the staff has to be paid, and consultants or other professionals engaged by the council would have to be paid, and that would be paid out of the revenues, but also via subvention provided by the Minister of Finance.
Senator Diana-Ryan.
Thank you, Madam Chair. So then, in this case, we don't need to make any sort of provision to indicate that subventions would be available to the council from the Ministry of Finance, just a matter of clarification.
To be clear, we do not need to make provision for that.
Minister said that there is no need to make for such a provision.
Okay.
I find it very interesting that you all can hear me. Is it that I am naturally loudmouthed? I don't know. Senator Vera.
Clear in your speaking.
Yes.
Minister, I just wanted to make a couple suggestions in terms of the remit of the minister's ability to make regulations. I was going to suggest for prescribing what constitutes unprofessional conduct, in case you want to expand on the Code of Ethics, for regulating the manner of applying, using the funds of the council, and maybe just as a general catch-all, for prescribing anything required or authorized by this act to be prescribed. This is at 62.
To be clear, Senator Vera is referring to expanding 60 sub 2, where we currently have A to D, to expand those areas, right? Is that what you're proposing?
Yes, Minister.
To be prescriptive, more prescriptive in respect of 62 by adding those 3 areas you've read out.
So what I'm suggesting is that the minister have a little more expansion, not prescriptive. So, for example, for prescribing what constitutes unprofessional conduct, that's a nice provision to have.
Well, Madam Chair, the 60 sub 2 really gives the minister a broad range to operate in, with the use of the words without limiting the generality of the foregoing, and then prescribes, some specific areas. Do you believe that the absence of a limitation would not cover the things you've read out?
I take the point. It's a drafting style. To me, sometimes I think it's better to have than to want, but I take your point.
Thank you.
Question is that clauses 59 and 60 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses. Senator Mark?
I just want to get some clarification
Sure.
on 59.
On 50, can you speak up?
I'm trying
Yes.
to get some clarification.
Sure. On clause 59?
59.
Yes.
Honorable Minister, I am not too clear in the legislation where staff monies, payments will be coming from. No, I know that the Honorable Chair raised the question.
No,
but
Senator Mark, hold on. Senator Deonorine raised that question in respect of clause 59, and it was answered by the minister. In respect of, yes, in clause 59.
yeah, I understand what you're saying, but I'm still not happy with that. His response.
Well, is it happiness we're dealing with?
No,
or is
well,
it clarity?
in other words, I'm not clear
Okay.
on the response, because there must be a provision in the legislation to indicate where the staff will be getting payments, how they're going to get paid. And you are saying that we don't need to put in the legislation any reference to subventions from the state. So where is the money coming from, Madam Chair? That's all. I'm
Sure.
not clear.
Senator Vera?
Thanks. What tends to happen, Senator Mark, is that the council will get the funds from the fees, the license fees. So when you look down here for the professional licensing and the renewals and all of that, that is money that the council would use for running their day-to-day activities. Now, if government is going to give us subvention on top of that, well, that's nice to have, but it would tend to come usually from the fees paid.
Yeah. So, honorable senators, the question is that clauses 59 and 60 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 59 and 60 now stand part of the bill.
Clause 61.
The question is that clause 61 stand part of the bill. There is an amendment from Senator Mark and from the Attorney General. Senator Mark?
Yes, Madam Chair, because we are being told that everything is going to come from fees and nothing from the government, then we don't understand why the minister is being given the power to make these regulations and to make changes to these schedules, I should say. And therefore, I would like to put the council in the driver's seat because they are the ones who will be funding this organization. And therefore, I'm suggesting that we reword 61 for it to read, the council, with the approval of the minister, may amend by order, subject to an affirmative resolution of the Parliament, the first, second, third, fourth, and fifth, and seventh schedules. I think, well, I see the eighth is being added here. So I believe, Madam Chair, this would really represent and reflect the reality in this particular section of the legislation. That is my submission.
Senator Vera?
Well, Senator Mark, it usually would be the minister that would have to bring the regulation. But for example, with the fees, we had an experience some years ago with the Dental Council where the fees that were originally there were very low. And so it was necessary for the minister, because this is already now set out in statute form. And so an amendment would be made in order to change any of those fees. So if they, in 3 or 4 years they wanted to increase it, that's why you would have to have the power.
Minister?
Chair, Senator Mark has obviously found a new and creative way to make the same point whenever the issue of the lawmaking, the regulatory making function of the minister. To say that the council is in the driver's seat is to completely ignore the structure of the legislation. So the minister, as Senator Mark knows as a former Minister of Public Administration, the minister has a significant role in the legislation, and it is the minister who, from Clause 5 onwards, appoints the council, and throughout the legislation, the minister has responsibility. But you would see at Clause 6, the council, once constituted, has the responsibility to advise the minister from time to time, and in particular, to make recommendations to the minister for amendments to the Act, so that the council is not in the driver's seat entirely. The minister has a role, and that role includes what is at 61. And as we have done on many occasions, the government wishes to have the formulation as it is there. We do, in fact, we have put forward an amendment to what we have in the bill, but we do not accept the amendment proposed by Senator Mark, which is to have the order subject to affirmative resolution.
That you make reference to the Legal Profession Act and look at 35 subsection 4 to reinforce the point I'm making about the council, having that authority to make those, to make changes rather, or the amendments to the schedules, because this is a similar development that is taking place, as I said, in the Legal Profession Act. So there's not anything strange in that context. The only difference here is the Chief Justice replaces the minister. So, Madam Chair, that is my submission, and that is why I'll stick to my submission.
Senators, the question is that clause 61 be amended as circulated by Senator Mark. Those in favor say aye. Those against say no. I think the noes have it. The amendment as circulated by Senator Mark is not accepted. Minister, there is an amendment circulated by the Attorney General.
The amendment proposes two things. The first is to make reference to the orders being subject to negative resolution of Parliament. So we propose to insert after the word order the words subject to negative resolution of Parliament. That's the first proposal. And the second is to include within the references to the schedules, after the word fifth, the word sixth. And those are the two amendments proposed to clause 61.
Yes, the question is that clause 61 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 61 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 61 as amended now stands part of the bill.
Clauses 54 to 57 revisited.
The question is that clauses 54 to 57 now stand 54 to 57 stand part of the bill. Minister, do you have the...
Madam Chair, we propose, in respect of the recommendation of Senators Choate and Vieira, we propose to insert a new section 57A, which would read, notwithstanding any other written law to the contrary, comma, a prosecution for a summary offense under this act may be commenced.
Fair enough. This road was to ask you to slow down because I have to take it down.
Right.
So notwithstanding any other written law to the contrary.
Any other written law to the contrary, comma, a prosecution for a summary offense under this act may be commenced before the expiration of 5 years after the commission of the offense, or 1 year after the discovery thereof, whichever date last occurs.
Notwithstanding any other written law to the contrary, comma, a prosecution for a summary offense under this act may be commenced before the expiration of 5 years after the commission of the offense or 1 year after the discovery thereof, comma, whichever date last occurs.
Yes, Madam Chair,
Yeah.
that is it.
So let us...
Clauses 54 to 56.
The question is that clauses 54 to 56 stand part of the bill. The question is that clauses 54 to 56 now stand part of the bill.
54C.
Yes?
Guide me here. Am I to assume that the spelling of practice as a verb with a C instead of the British thing, if it will be picked up in final vetting? In C?
Madam Chair,
Practice.
yes, it would be. Yeah.
Or are we going to change it to an S now, British English?
The CPC assures that it would be picked up in the final vetting and it would be changed. Madam Chair.
So, Honourable
I hope
Senators,
so. It occurs also in some of the schedules, huh? So,
Honourable Senators, the question is that clauses 54 to 56 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 54 to 56 now stand part of the bill.
Clause 57.
The question is that clause 57 stand part of the bill. The question is that clause 57 be amended to read as follows. To insert a 57A. No. So, Honourable Senators, the amendment that had been put forward will be treated as a new clause, which is dealt with after we treat with all the other clauses in the bill, because it will be a new clause 57E. So I'm now going to put the question on clause 57 as it stands in the bill. The question is that clause 57 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 57 now stands part of the bill.
New clause 57A.
The question is that new clause 57A be read a second time. Those in favour say aye. Those against say no. I think the ayes have it. New clause 57A will now be read a second time.
New clause. New clause 57A.
Honourable Senators, the new clause 57A will now be read out. Notwithstanding any other written law to the contrary, comma, a prosecution for a summary offence under this act may be commenced before the expiration of 5 years after the commission of the offence or 1 year after the discovery thereof, whichever date last occurs. So the question is that new clause 57A be added to the bill. Those in favour say aye. Those against say no. I think the ayes have it. New clause 57A now stands part of the bill. Senator Mark, you have proposed a preamble to the bill in your list of amendments. I'm treating with it here because there is no preamble to the bill. And therefore, Senator Mark, it is my view that this cannot be treated with, because there's no preamble to the bill, so that it is not something that falls within the remit of the bill. Yeah? Thank you.
Schedule 1.
The question is that Schedule 1 stand part of the bill. No, I think Senator. I think you have a proposed amendment to the schedule, to Schedule 1. Senator Dylan Remy.
Madam Chair, it's to change the fees. The first schedule, professional license, instead of $1,500, changed to $1,000. Renewal of professional license, instead of $1,200, substitute to $500. Temporary license, that's E. Temporary license E, delete 2,000 and substitute 1,500. And F, reissue of a temporary license, instead of 1,500, substitute 1,200. Madam Chair, it was in the discussion with the planners, they had recommended the changes.
Hussein.
Thank you very much, Madam Chair. I understand the policy of the amendments coming out from Senator Dylan Remy, and I agree in terms of a reduction, but not right through. If we look at, for example, the legal profession, the person's fees is dependent on their years of experience. So under 5 years, over 5 years, over 10 years, over 15 years, and then senior counsel. And the fees differ at various categories in terms of experience and the years of call to the bar. I wonder if this can be a consideration of the government in terms of the experience of the planners, so that those persons who are now qualified pay a lower fee than those who may have been qualified for over 10 years. Because if everyone pays the same fee across the board, there may be a latent unfairness that is found in this particular schedule.
Madam Chair, the fees we've just discussed the proposed clause 61. The fees are always subject to review up or down. In determining the fees that are prescribed in the first schedule, we considered across professionals, across all the professions. These fees are actually on the lower side, and in the case of some professions, on significantly lower side, taking into consideration that this is the first set of fees that are being prescribed. We also took into consideration that a significant number of the urban planners would be employed by the state, and in the normal practice of the state, the fees would most likely be paid by the employer. So the government is comfortable with what is prescribed, and if in the future there are concerns or considerations by the profession itself, those would be addressed by the line minister at that stage, and maybe the power under 61 would be used.
Madam President, the minister said something very interesting, and I think I would like to place this on record. If the policy of the government is to, in fact, have most of the planners employed by the state, and then, if I may mushroom the point, that the state will pay, it seems as though that the state will exercise a lot of control over the planners, because then they would be the same ones who decide the composition of the commission, who they appeal to, and also the fact of the rules of the court. So that is a point I just want to put on record, that I see that the planners may be disadvantaged in terms of the policy going forward.
Senator Dylan Remy, do you wish to say anything else?
No, Madam Chair.
So the question is that Schedule 1 be amended as circulated by Senator Dylan Remy. Those in favor say aye. Those against say no. The amendment as proposed by Senator Dylan Remy has not been accepted. The question is that Schedule 1 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Schedule 1 now stands part of the bill.
Schedule 2.
The question is that Schedule 2 stand part of the bill. The question is that Schedule 2 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Schedule 2 now stands part of the bill.
Schedule 3.
The question is that Schedule 3 stand part of the bill. Senator Mark, you have an amendment?
No, just a clarification.
No, you actually have circulated an amendment.
Oh, yes, and exactly that is, yeah. Suggestion, Madam Chair, that we include a third category in support of those applications. And it is seeking to ensure that those persons would provide a certificate of good character from the TTPS.
Madam Chair, we do not accept the recommendation. We believe that the certificate of good standing from the TTSP is sufficient. And again, as I said before, these are matters that could be revisited in line with Clause 61 and the power to deal with the schedules in the future. But at this stage, it is sufficient to have a certificate of good standing from the TTSP.
So, Honourable Senators, the question is that Schedule 3, the third schedule, be amended as circulated by Senator Mark. Those in favour say aye. Those against say no. The amendment has not been accepted. The question is that Schedule 3, the third schedule, now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Schedule 3, third schedule, now stands part of the bill.
Schedule 4.
The question is that Schedule 4, the fourth schedule, now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Schedule 4, the fourth schedule, now stands part of the bill.
Schedule 5.
The question is that the fifth schedule, Schedule 5, now stand part of the bill.
Circulated for the minister's consideration. Slight amendment. Wherever was appears, I'd like that to be deleted and replaced by is. And I think that, I think it would read better rather than dealing with the past, we deal with the present.
Senator Mark for his suggestion, and it's accepted.
So the question is that the fifth schedule, Schedule 5, be amended as circulated by Senator Mark. Those in favour say aye. Those against say no. I think the ayes have it. The question is that the fifth schedule, Schedule 5, as amended, now stand part of the bill. Those in favour say aye. Those against say no. The fifth schedule, Schedule 5, now stands part of the bill. And the fifth schedule, Schedule 5, as amended, now stands part of the bill.
Schedule 6.
The question is,
I'm very, very sorry. You'll just guide me?
I suspect I'm going to say I am very sorry too.
Yeah, ma'am, no, because this is just clarification.
Sure.
Would Form 2 and 3 of the said schedule have the same changes, Minister? Okay, sorry, ma'am, that's all I want. Sorry about it.
Senator Mark?
No, I just wanted to make sure. Thanks, ma'am.
Sure.
Okay, thank you. You're so kind.
Schedule 6.
The question is that Schedule 6, the sixth schedule, now stand part of the bill. Just one sec, Senator Dearnorine.
Thank you, Madam Chair. My question is with respect to Part 1, the general obligations of the Code of Ethics. Number 2, subsection B, it says that the urban and regional planner shall obtain professional indemnity insurance when so required by law. And it is so required by law under the Planning and Facilitation and Development Act. I believe is under Section 81. However, that section of the Planning, Facilitation and Development Act is not yet proclaimed, and Part 1 of the Code of Ethics in this bill is actually omitted from being considered for professional misconduct. Therefore, my question is, in the absence of not being able to be considered for disciplinary proceedings, if an urban and regional planner does not have professional indemnity insurance, would any penalties be associated with that in the absence of the full proclamation of the Planning and Facilitation Development Act?
Madam Chair, we did in fact indicate throughout the debate that one of the reasons, the main reasons for not fully proclaiming that piece of legislation was, of course, the amendments which had to be made, which have been made, but also the need to have this piece of legislation, because throughout the facilitation of development legislation, we have assumed that we would have these urban regional planners. It's a point that was made in the debate. So the intention is to proclaim this legislation, fully proclaim the Facilitation of Development Act, and that would give effect to the provision for professional indemnity insurance.
Madam Chair, so if I understand correctly, the Minister is saying that with the full proclamation of this law, the Urban and Regional Planning Council law, we would be able to have the full proclamation of the Planning and Facilitation and Development Act, which would kick in subsection 2 of Part 1 of the Code of Ethics?
That is the intention, Madam Chair.
Okay, thank you.
Senator Mark?
Yeah, Madam Chair, in the sixth schedule, the clause 61, which we have already approved, did not identify the power, or it does not empower, I should say, the minister, after consultation with the council, to by order amend the sixth schedule. That is the Code of Ethics.
We accepted the amendment of the Attorney General, which included the sixth schedule.
Oh, instead of 5th and 6th. All right, I withdraw.
Thank you. So the question is that Schedule 6, the sixth schedule, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Schedule 6, the sixth schedule, now stands part of the bill.
Schedule 7.
The question is that Schedule 7, the seventh schedule, now stand part of the bill. The question is that the seventh schedule, Schedule 7, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Schedule 7, the seventh schedule, now stands part of the bill.
Schedule 8.
The question is that Schedule 8, the eighth schedule, now that stand part of the bill. The question is that Schedule 8, the eighth schedule, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Schedule 8, the eighth schedule, now stands part of the bill. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Minister of Agriculture, Land and Fisheries.
Madam President, I wish to report that the Urban and Regional Planning Profession Bill 2019 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agrees with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Urban and Regional Planning Profession Bill 2019. Those in favour say aye. Those against say no. I think the ayes have it. Minister of Agriculture, Land and Fisheries.
Madam President, I beg to move that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto be read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto.
Motions?
Minister of Agriculture, Land and Fisheries.
Madam President, I beg to move the following motion standing in my name. Whereas it is provided by Section 5.1 of the Land Acquisition Act, Chapter 5801, that the President may by order declare that land is required for public purpose, and whereas it is provided by Section 5.2 of the Act that Parliament may by resolution approve an order made under Section 5.1, and whereas the Land Acquisition Requisition Order 2018 was made by the President under Section 5.1 of the Act as legal notice number 190 dated the 19th day of December 2018, and whereas it is expedient to approve the said order, be it resolved that the Land Acquisition Requisition Order 2018 be approved. Madam President, in moving this motion, I'm constrained to address issues relevant to motion number 3, made pursuant to the Land Acquisition Act, Chapter 5801. These matters are interrelated. I therefore seek leave, Madam President, to debate these matters together. Thank you.
Honourable Senators, is this the wish of the Senate? Leave is granted. Minister of Agriculture, Land and Fisheries.
Thank you, Madam President. Madam President, these two motions deal with acquisition of land as provided under this statutory regime. Madam President, the relevant legislation is the Land Acquisition Act, Chapter 5801. And basically, Madam President, there are 3 critical steps to be taken in relation, I would say 4, in relation to the acquisition of land for a public purpose. The first, Madam President, is set out at Section 3.1 of the Land Acquisition Act, and that is the purpose for which the land is being acquired is a public purpose. And Madam President, we are all familiar with the way it works. From time to time, for the purpose of providing services to the public, for the purpose of providing facilities to the public, there may not be a situation in which the state has land in a particular location. Or, Madam President, it might be that there is state land in a particular location which can be used for public purposes, but that land may be only accessible via private land, or that state land may be interspersed by private land. So the requirement of the law is first at 3.1, there is a public purpose tied into the acquisition. Madam President, the second step is the requirement of notice, and there are 2 forms of notice under the legislation. Under Section 3.1 of the Land Acquisition Act, there is need for notice to be published in the Gazette and 2 newspapers. And there is also the need for notice under Section 3.2 of the Land Acquisition Act for notice to be served on persons with interest in the land and for notice to be served on the property itself. So that's the core requirement, the public purpose and the service of the appropriate notices. Madam President, the next step is set out at Section 4.1 of the Land Acquisition Act, and that is the provision for the Commissioner of State Lands to take possession of the land which is being acquired once a 2-month period has passed. The Commissioner does not have the power to take possession prior to 2 months, but 2 months after the service of the notice, there is no formal vesting that is required. The Commissioner of State Land under the Land Acquisition Act can take possession to commission the works or the activities which are required and consistent with the public purpose. And I said before, Madam President, there is a third step and a critical step if your land is being acquired, and a very problematic area, I must admit, and that relates to the compensation. There's provision for the parties to arrive at a figure by private treaty, and private treaty may be prescribed, and there's a provision for the state to compulsorily acquire, in which case the Commissioner of Valuations must make a determination of the value, and that is to be paid to the person whose land is being acquired under the law. Madam President, I said it at the start, the third part is a very important part, because in the case of the 2 motions before us, the lands have been put to use for a very long time. The process for acquisition has been undertaken. There's been compliance with the requirement of the law. But to complete the process, we need to have this order approved by this Parliament in order to effect payment in relation to the land. And Madam President, the 2 parcels relate to 1, a parcel of land comprising approximately 2.0234 hectares more or less, situated at Realize Road, Princestown, in the ward of Savannah Grande in the county of Victoria. Madam President, the public purpose for which this land was acquired, and I must say the cabinet decision relating to the acquisition of this land is a cabinet decision of 16 years ago, 2004. The decision was made by the cabinet to acquire this land for the public purpose of the establishment of a recreational ground. I must say, Madam President, that while cabinet took that decision in 2004, persons in the community believe that that land was actually being used for a recreation ground from about 10 years before. So it's been a substantial period of time that has passed as when the use commenced, when the cabinet made the decision, and when the proceedings commenced in accordance with the law. Madam President, the Commissioner of Valuations has determined that the land is valued at $510,000. It's a fair estimate for the land, and the main intention of this motion is to complete the proceedings in accordance with the law by the approval of the order today, so that the payment, which is $510,000, may be effected to the persons whose land was taken for that public purpose. Madam President, the second parcel of land is in relation to a project that is well known to Senator Kand and I suppose well known to anybody who has entered Mayaro via Manzanilla, because we all remember that wooden bridge that you had to traverse. Senator Hussein, you're too young to remember that one. That wooden bridge that you had to traverse in Manzanilla, and it was the Minister of Works, Sadiq Baksh, who commissioned a replacement of that bridge. And of course, we miss it sometimes, but it is that project that led the state to have to acquire 4 parcels of land, 4 small parcels of land on the approach to the bridge and the exit from the bridge in order to have the appropriate alignment as you enter and as you exit. And again, the public purpose for which those lands were acquired was the purpose of construction of the bridge. The appropriate notices that were served and the process was followed up to the point of completing by the approval of this cabinet. So, Madam President, the second motion relates to the acquisition of land, 4,594 square meters, for the purpose of the acquisition of land for the Manzanilla-Mayaro Road improvement to the road alignment and bridge construction project. The valuation of the land was undertaken by the Commissioner of Valuation, Madam President. A value of $125,000 was affixed to the land to be acquired, and once this motion is approved, the payment could be effected to the affected persons. It is in relation to 4 parcels of land, together comprising 0.5793 hectares, located at light pole LV15 along the eastern side of the Manzanilla-Mayaro Road, Ottawa Village, Mayaro. And it's 4 parcels, as I said, one comprising, and I switch from hectares here to meters, and I hope I don't confuse anybody, 101.1 square meters. Second parcel comprising 655.5 square meters. The third parcel comprising 441.6 square meters, and the fourth comprising 4,594.5 square meters, and the total cost is $125,000. Madam President, I beg to move.
Honourable members, I shall now propose the question for debate. The question is, whereas it is provided by Section 5(1) of the Land Acquisition Act, Chapter 5801, hereinafter referred to as the Act, that the President may by order declare that land is required for a public purpose. And whereas it is provided by Section 5, Sub 2 of the Act, that Parliament may by resolution approve an order made under Section 5, Subsection 1. And whereas the Land Acquisition Requisition Order 2018 was made by the President under Section 5, Subsection 1 of the Act, as legal notice number 190, dated the 19th day of December 2018. And whereas it is expedient to approve the said order, be it resolved that the Land Acquisition Requisition Order 2018 be approved. Honourable Senators, please be reminded that in accordance with Standing Order 48.1, leave has been granted to debate along with this matter motion number 3 on the order paper. Senator Mark.
Thank you, Madam President. Madam President, acquisition generally is a very, very challenging and difficult matter to deal with. We have been involved as a parliament for decades in acquiring properties under the appropriate legislation known as the Land Acquisition Act. And Madam President, I can tell you that acquiring properties by the state in order to carry out what is called public works or for public purposes can become very emotional for many, many citizens. And it can also become disruptive to family life, businesses, farming, among other things. But as the Honorable Minister indicated, there is a three-stage process involved in this acquisition exercise. And he has outlined those stages for our consumption. Madam President, the matter that we are dealing with this evening are two sets of lands that would have been acquired over several years ago. And we have these recorded in legal notices number 34 and 190, respectively. In the first instance, we know that sometime in 2001, the file was signed off through this plan survey by the Director of Surveys, Madam President, and that is dated the 16th of January, 2001. The properties would have been acquired thereafter. But we are now in 2020. And we are now coming to provide compensation. I don't know if I got the minister correctly, Madam President, when he said that the value of the land acquired under legal notice number 34 for the construction of a bridge in the Mayaro area, the total value as assessed by the Commissioner of Valuations, is it $125,000? Is it that what I heard, Honorable Minister? Is it $125,000? Madam President, if we are talking about 4 parcels of land and 4 individuals that are involved, I find this sum of money to be very, very measly. Madam President, that is the challenge that we have when we deal with land acquisition, which is acquired on a compulsory basis. It is never determined on the basis of current market value. It is always determined on the past market value at the material time, and thereby depriving citizens of what I call a meaningful return on their properties. So here it is, Madam President, we are being told that 4 parcels of land, one belonging to Dolores Brute, a second, that's the first one comprising of 101.1 square meters. The second belongs to, or belonged to one Mr. Errol Mento, 655.5 square meters. The third belonged to one Clunis Batiste, 441.6 square meters. And the last one, Madam President, is a parcel of land comprising 4,594.5 square meters belonging to one George Bovell. And Madam President, we are being told that all of these pieces and parcels, the Commissioner of Valuation has valued all of these parcels that I have just outlined at a price, at a value of $125,000. Now, Madam President, when were these lands acquired? It would have been sometime in 2001. And they began to acquire these 4 parcels in order to construct the new bridge. But, Madam President, we are in 2020. I do not know if these people are still alive. But we are now determining through a requisition order dated February the 18th, 2019, to pay, Madam President, to those people once these orders are approved today, the sum of $125,000. Madam President, something has to be wrong with that system of land acquisition in this country. We definitely, Honorable President, have to look at reassessing, reforming, and overhauling that system. How can we justify in 2020 paying persons $125,000 for 4 parcels of land, and those lands were acquired, Madam President, in the year 2001, according to the legal notice that is before us? It is unfair, Madam President. And, Madam President, it begs the question, when the minister rises to speak and to close this debate, maybe the minister may want to tell us what is the total value of outstanding monies owed to citizens whose lands were compulsorily acquired over the last few years that he can share with us. I think that would be important. How many people? Madam President, so that is one aspect of it. Then we go to the second legal notice that I mentioned a short while ago. And we are made to understand by the Honorable Minister that according to this legal notice 190 and this order entitled Land Acquisition Requisition Order of 2018, this land totaling 2,234 hectares, Madam President, which was part of a larger parcel, we are being told, was acquired back in 2004 for recreational purposes. So it was a recreational ground that was being acquired for that purpose, that is public purpose, in the year 2004. And Madam President, the land belonged to a gentleman whose full name cannot be seen. The first name is not there. But this individual lived on Realized Road in Princestown. And, Madam President, the land which was acquired by the government in 2004, the gentleman in question, Mr. Raphael, is no longer with us. He is now deceased. So, Madam President, in 2004, we acquire these lands for recreational purposes and the public purpose is recreational. They acquired it for that public purpose, so that citizens in that part of the island can, in fact, engage in recreational activities. But, Madam President, why did it have to take 16 years for us to get this requisition order? And we are being told, Madam President, that the value of the property or the lands that were acquired is just about $500,000 and above dollars, $500,000. Okay? But look how long it took, Madam President, to acquire the value. Look how long it took to get to where we are. So we are now being told, Madam President, that when this order is passed legally and approved legally, only then would the former person who actually was the owner of this land, his family, will now be able to access, acquire, receive the $510,000. Madam President, I am saying something is definitively wrong with such a system. Something is wrong. And Madam President, I would urge the government to pay attention to this development. It is sad. Madam President, you and I are aware that recently the government acquired lands in the interchange to construct the interchange at Currap. And as we speak, I know there are some 14 families who still have not received their compensation, although we are using the Currap interchange. But people are out in the rain, and we don't know when the government is going to meet their payments. We know that the government has, in fact, provided a certain amount of money, I think just about $80 to $90 million. But where and when are they going to receive their monies? And, Madam President, I raise this to let you know that there may be hundreds of citizens in our country who have been waiting and waiting and waiting, maybe for 10 years, maybe for 20 years, maybe for 30 years, and they are yet to receive their compensation for their lands, Madam President. So I'm hoping that the Honorable Minister would be able to share with us, give us some data on this matter, Madam President, so we would know exactly how many cases are still back, how many cases are still to be settled by his ministry, and the period of time that we are dealing with, and the number of citizens, Madam President. Madam President, I believe that the system of land acquisition in this country is weighted heavily in favor of the state at the expense of the citizens. And therefore, we have to do some overhauling of this system in order to ensure that there is justice in this particular exercise, Madam President. And I would want to ask the Honorable Minister, in winding up, that we get some information from him on this matter. We cannot object, Madam President, to lands being acquired for recreational purposes. We cannot object for lands being acquired for infrastructural development like the bridges or the bridge that was constructed. These are important developmental milestones as we proceed in our transformation and growth and development as a nation. But, Madam President, as we develop, as we engage in sustainable development, as we focus on the environment within that framework, I ask this Honorable Senate and the Minister in particular, do not forget those whose lands we compulsorily acquired. We need to get a system in place, Madam President, in closing. We need to get a system in place to have payment made to those citizens whose lands have been compulsorily acquired in a much speedier manner, Madam President. We cannot continue having 10 and 15 and 20 years wait. So I look forward to the Honorable Minister when he is winding up, or concluding, I should say, his contribution and in response to these two matters that are before us, that he would be able to provide us with the information and the clarification needed, and he can tell us what steps his government, outgoing government at any rate, so we will have to deal with the overhauling of the system as the incoming government. So, Madam President, I still believe he should brief us on the current status of all outstanding matters, the value involved, the number of people, and how long people have been waiting for their compensation for lands compulsorily acquired. Madam President, I thank you for the opportunity to, and Madam President, may I say, in leaving, we were only informed. Although it was on the order paper, I plead guilty, it's there, but we were only informed 10 o'clock this morning that we had to deal with this thing this evening. But as an old veteran and a soldier, you know, I always rise to the challenge. I thank you very much.
Senator Hussain.
Very much, Madam President, for allowing me to make what is a very short intervention on this particular debate dealing with these two motions that are on the order paper before us. And as Senator Mark would have indicated, Madam President, we on this side have no argument or no quarrel with the government with respect to the purpose for which the land will be acquired. That being a public purpose, one, for the road alignment, for the construction of a bridge, and two, for the purposes of a recreational ground. Now, Madam President, the short points I would like to raise is firstly, dealing with the matter of the 4 parcels of land that measure 0.5793 hectares, which is approximately 1.2 acres for the purpose of the road alignment for the bridge construction. And this was in fact gazetted by legal notice number 34 on the 21st of February 2019. Now, when I looked at the legislation, I probably would have missed it in the winding up of the minister's presentation. At section 12 of the Land Acquisition Act, it determines the calculation in which the state will use for the assessment of the land. And it reads that the value of land shall, subject as hereinafter provide, be taken to be the amount which the land, if sold in the open market by a willing seller, on the condition in which it was, might be expected to realize at the date of taking possession of the land or the date of publication in the Gazette of the declaration made under section 5.3, whichever is earlier. So one matter of clarification, and this goes for the both pieces of land, what was the date of possession of the land in accordance with the Act? Because we have the date of the publication of the Gazette. I probably would have missed it, but if I can ask the minister to please repeat what day in which the possession of the land was taken. The second issue I would like to raise is with respect to the value of the land. Now, we are asking this Parliament to approve an order in which the 1.2 acres of land was acquired at a cost of $125 $129,000. And this, Madam President, is divided into 4 pieces. The first parcel measuring 101.1 square meters, the second parcel measuring 655.5 square meters, the third parcel measuring 441.6 square meters, and the fourth parcel measuring 4,594.5 square meters. Now, I would like to ask the Minister if he can give us a breakdown under which each landowner will get, because you have to now divide $125,000 into 4 pieces, but the lands are measuring various sizes. So if the Minister can also indicate to us what will be the compensation to each of these persons. When I go back to the other parcel of land that deals with the recreational ground that belongs to a person only by the name Ramphal, who is now deceased, can the Minister indicate whether or not this particular person estate was in fact granted? Because if we're asking the Parliament to approve payments to the person who is deceased, therefore the estate must be in a state of readiness in order to accept the compensation that will be coming from the state. Notwithstanding, it's that will be the larger number, which is $510,000, which measures approximately about 5 acres of land. So it's a very large parcel of land, and where the state is only paying $510,000. Now, Madam President, the point is that we understand that there's a problem in this country with respect to land acquisition. It's always a very contentious matter. Anytime a government announces any project that results in the displacement of persons, you find that there's a bit of resistance because persons have emotional attachment to their land and their property. And if this is so, and in these particular cases, these persons must be adequately compensated for their particular land, because land is one of the most valuable assets someone can in fact own. I know there's an issue with respect to resources at the Office of the Commissioner of Valuations, who play a very critical role when it comes to valuation of lands. And Senator Mark raised the point that why is it that it takes so long for persons to be compensated when the state is having the benefit of the land? And this is unfair, Madam President, because the state acquires the land, the person is dispossessed, and they are not compensated for that period of dispossession, because you're only calculating the date of the value of the land from when the state takes possession or the date in which the publication was made in the Gazette. So you have to look at whether or not these persons may be entitled to some additional compensation for that period in which they were in fact disentitled, whether or not it can be calculated on the rental value of the land at that material time. The last issue I would like to raise, Madam President, is that there's a particular piece of land which has in fact been acquired by the state. It's currently in use. Everyone knows about it. It's a matter of public interest. But yet we don't know what the value of that particular piece of land is. And everyone knows which land I'm talking about. And that is the land on which the Curep interchange is built on. That land is the Kedona parcel of land. And up till now, the citizens of this country, no matter how much we ask, we always hear that it's not being evaluated as yet. Why is that so? Why is it that we can't know how much money is being paid for that land that we are using currently right now? So it shows, and it goes back to the fact that there is some level of resource issues when it comes to the Commissioner of Valuation and the Director of Surveys in Trinidad and Tobago. So I would like to say, Madam President, in closing, that we need to have a proper, comprehensive review of land acquisition when it comes to the Parliament, and also compensation to citizens. Because it's unfair that the state uses persons' land without them being afforded proper compensation. And I thank you very much, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, in moving the motion, perhaps I was not absolutely clear in saying that the Land Acquisition Act is prescriptive. It requires very strict compliance. The process does not allow the Parliament to review evaluation. That's the work of the Commissioner of Evaluations. It does not allow the Parliament to review the surveys. It does not allow us to get into what each landowner receives. It does not allow us to get into the estate administration of deceased landowners. It is prescriptive, requires strict compliance, and almost everything my colleagues, Senator Mark and Senator Hussain, have said or asked for are outside the ambit of this motion. Madam President, the motion is a very narrow motion outside of which I do not plan to go, and I do not plan to carry this Honorable House. I therefore beg to move. Thank you.
Minister, did you utter the words I wanted to hear?
Yes, Madam President.
Honourable Senators, I remind you that the question will now be put on motions number 2 and number 3 on the order, people. Honourable Senators, the question is, be it resolved that the Land Acquisition Requisition Order 2018 be approved. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. The motion is therefore carried. Honourable Senators, be it resolved that the Land Acquisition Requisition Order 2019 be approved. Those in favour say aye. Those against say no. I think the ayes have it. The motion has therefore carried.
Thank you very much, Madam President. Madam President, it is a distinguished honor that I now beg to move that the Senate do now adjourn. Sine die.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Sure. Senator Mark.
Thank you very much, Madam President. Madam President, I have brought this matter, this matter, to address the need for the government to provide this Honorable Senate with detailed information of the procurement process used by NIBDEC and the name or names of the preferred suppliers of face masks at a cost of approximately $5 million. Now, Madam President, the government has indicated publicly through both the Minister of Finance and the Minister of Health that the government was acquiring tens of thousands of face masks or cloth masks in an effort to ensure that the citizens are protected from this COVID-19 pandemic. We were also informed that the government had chosen NIBDEC as the agency to invite tenders for face masks through this $5 million arrangement. They were the government agency acting on behalf of the Minister of Finance and maybe the Minister of Health. And they said that they were inviting parties to manufacture these cloth masks in order to combat the spread of COVID-19. And that these face masks were supposed to be distributed free of charge to the public. Madam President, $5 million of taxpayers' money would have been used by NIBDEC to invite persons, organizations, firms to produce, to manufacture, and through field distribute free of charge these cloth masks to the population. There was a deadline of April the 24th as closure for submission for proposal or proposed documents for this particular RFP. Madam President, we have not heard anything after this development. All we know is that we have paid, or the government has allocated, $5 million taxpayers' dollars, and we don't know, Madam President, which firms were recruited, at what cost to the taxpayers. We don't know as we speak, Madam President, who got these face or cloth masks in this country. The government has been, there has been non-transparency. There has been no accountability, Madam President, in the face of scarcities, in the face of a crisis of cash in this economy. Utilizing $5 million is a lot of money, Madam President. And I've brought this motion, this matter on the motion for the adjournment, to get from the government a detailed breakdown of our $5 million. Where did it go? Who got the $5 million? Which firms got the monies? What did they produce? What was the value of each contract that was issued to these firms, Madam President? The taxpayers need to know where their hard-earned tax dollars have gone. And that is why, Madam President, unless we in the UNC raise these matters in this parliament and outside of this parliament to get answers from the government, Madam President, it seems to us that the government is contented to not share information on these matters voluntarily. You have to force this government to account. You have to bring a matter on emotion for the adjournment, for the government to give information, for there to be transparency, for there to be accountability, Madam President. So therefore, as I said, we would like to know what is the status of this project. And Madam President, we'll also like the government, I'm sorry the Minister of Health is not here, but we would also like them to explain to this Parliament whether they are up to date with the WHO latest guidelines on these face masks. And especially in a country where we are being told that the curve has been flattened, and Madam President, it seems like given the percentage of persons who have contracted this particular deadly virus is very limited in our environment. But that is a matter for another occasion, Madam President. So, in closing, we call on the Minister or the government to explain to us in detail where the $5 million have gone, which firms have gotten it, the value of each, how much of these firms produce what, and, Madam President, most importantly, where did these face masks go? Who received them? What, in which communities? I didn't get any. I'm a member of this parliament. I didn't get a package to distribute, but my taxpayers' dollars went into the production and manufacturing of these cloth masks. But we never got, at least the Minister of Agriculture was kind to give us some seedlings to plant. We got that in a package. But, Madam President, we were not that fortunate to get from the government a package of cloth mask in an effort to distribute to citizens in this country. Not to say I'm asking, because we have done our own work on that front, and we have distributed tens of thousands to citizens throughout Trinidad and Tobago. So, Madam President, my motion is very straightforward. It's very simple. Accountability, accountability, and transparency. Thank you so very much, Madam President.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, as part of the government's continued efforts to reduce the spread of COVID-19, the Ministry of Health on April 5th, 2020, advised the general public that in addition to personal protection measures, individuals should wear cloth masks once they are out in public. The government, through the National Insurance Property Development Company, invited proposals for the local manufacture and supply of cloth face masks via a public tender on April 14th, 2020, which was advertised in the daily newspapers and on the NIPDEC website. Tender boxes were placed at 12 TT Post locations, as well as at NIPDEC's head office and Tobago office. The face masks will be distributed to the wider public through non-governmental organizations, members of parliament, and councillors. Madam President, the procurement process utilized by NIPDEC was initiated by a request for proposal, which outlined that proponents were to submit one proposal in accordance with requirements that included guidelines from the U.S. Center for Disease Control and Prevention for production of cloth face masks. In addition, the proposals were required to provide sufficient details for a comprehensive and firm offer for acceptance and implementation by NIPDEC. Prior to the close of the tendering process on April 24, 2020, one public notice was issued to provide clarification and completion of the required forms and to respond to frequently asked questions. The proponents, after satisfying all requirements, would then be required to enter into negotiations with NIPDEC prior to the award of a final contract. The details on the procurement of face masks by NIPDEC, Madam President, are as follows. At the close of tender on April 24, 2020, at 12 noon, 462 proposals were received, as summarized by location below. From Tobago, 36, Head Office, 235, Arima, 23, Chagonas, 29, Couva, 9, Diego Martin, 18, Lebre, 4, New Grant, 3, Point Fortin, 17, Rio Claro, 5, San Fernando, 40, Sanwo, 14, Sangre Grande, 11, and Tunapuna, 18, giving a total of 462. The bids were then categorized based on quantity that could be produced within a 7-day period. The categories were as follows. Petty, between 1 and 1,500 masks being produced within 7 days. Small, 1,500 to 5,000. Medium, 5,000 to 10,000. Large, 10,000 to 50,000. And mega, over 50,000. For the purpose of budget allocation, each category was allocated 20% or $872,800 of the amount budgeted to mask, which was $4,364,000. The methodology utilized for evaluation of the bids was as follows. Step 1, the process provided for proponents to satisfy the responsiveness criteria. Completed form of tender, completed applicant's information sheet, name, contact / authorized person, location based on county, identification card where applicable, NIS, BIR, and VAT numbers where applicable, access to materials, type of material available, quantity of material available, number of masks to be supplied in 7 days, sample attached, rate, cost per mask, bid price, VAT exclusive, alternative design, and sample accepted. A bid was deemed non-responsive and disqualified if the form of tender was incomplete, or the applicant's information sheet is incomplete, or the sample was not attached. Also, if via the first pass visual inspection by NIPTEC, the sample was not accepted. Table 3 lists the total responsive bids. In the petty category, we had 221 bids. In the small category, there were 77 bids. In the medium category, 27. In the large category, 17. And in the mega category, 4. Giving a total of 346 successful bids or qualifying bids. The samples for the responsive bids were submitted to the Trinidad and Tobago Bureau of Standards for technical evaluation. Using the Association Française de Normalisation and for specification S76-001 issued on the 27th of March 2020 as a guide or reference document, the TTBS Fiber Products Laboratory developed the following criteria for conducting tests on the mask. 1, design and visual inspection, examination of the design of the mask. 2, fit verification, that the sizing of the mask should align to the average morphology of the target population. 3, washability. Undertook 5 washing and drying cycles of each mask using AATCC standard reference detergent. Dimension suitability. Confirmation that the mask remained well fitted and not being deformed after the wash and dry cycles. 5, identification, verification of the type of the fabric fiber. And 6, air permeability, adherence to the AFNOR specification using the ASTM D737 standard test method for air permeability of textile fabrics. 157 submissions were successful at the end of the exercise and selected for negotiations as per Table 4. Successful technical evaluations in the petty category, 117, who indicated they were able to produce 69,037 masks at the cost of $1,213,948. Small category, 19 persons to produce 69,822 masks at a cost of $878,835. The medium category, 13 qualifying people offering to produce 101 masks at the cost of $1,458,360. Large category, 616,000 masks at $1.581 million, and the mega category to produce 500,000 masks at the cost of $5 million, with a total offering through qualifying bidders producing 856 masks. That was an offer at a total cost of $10.132 million. Based on the successful 157 submissions, the lowest price per category was compiled to determine the most suitable price to negotiate as per detailed in Table 5. Under that table, Madam President, we had prices ranging from $5 per mask to $10 per mask. The determination of the negotiated price was based on the frequency distribution for the prices proposed by the bidder. In this regard, out of the 157 submissions, 23 offers were made at $10 per mask. In addition, the lowest price per category, ranging from $5, $5.75, $7.60, and $8, were only offered by 2, 1, 1, and 4 bidders per product price category, respectively. Moreover, outside of these prices, there were 12 offers at $12 per mask, 29 offers at $15 per mask, 24 offers at $20 per mask, and 18 offers at $25 per mask. Madam President, to ensure that the greatest number of masks are manufactured, the standard rate of $10 was offered to the successful proponents, with 113 proponents accepting. Quantities were assigned based on budget allocation per category, using bidders' capacity to produce within the 7 days as per the RFP. Any surplus funds per category were allocated to another size category to ensure that all funds are fully utilized. The allocation of award of contracts are as follows. In the petty category, 80 proponents to produce 48,000 masks at the price of $489,000. In the small category, 16 producing 57,000 at a price of $578. In the medium category, 10 $82,000, in the large category 5, producing $103,000, in the mega category 2, producing $143,000. Madam President, on June 10, 2020, NIPDEC submitted its recommendation list of awards of contract.
Minister, your time has expired.
Thank you, Madam President.
Senator Richard, I remind you, you have 10 minutes.
Thank you very much, Madam President, and thank you for the opportunity to present this matter, motion on the adjournment, which may very well turn to be the final motion in the adjournment this session. The issue is, of course, the need for the government to provide details of its plans for ensuring a robust state digital communication network, particularly in rural communities, to facilitate connectivity to government services. I don't know if many people may know, but 32 years have elapsed since Microsoft issued its Windows 1.0 operating system. Could any of us have imagined 30 years ago that today we'd be carrying out our entire music libraries, photo albums on tablets, phones, and smartphones, and able to communicate with the entire world, get entertainment, arts, and purchase all kinds of goods and services in real time from anywhere in the world, or have our entire offices in our pockets? Well, certainly during this COVID-19 pandemic, which is far from over, a new normal has been imposed, and a robust state digital integrated ICT network is vital to the new normal in any society. There is an imperative for a successful new normal, which includes Zoom, Microsoft Teams, Skype, Google Hangouts, WebEx, WhatsApp, Blue Jeans, Slack, appear in Facebook or IG groups. Digital technologies supported by a robust digital communication network is now ubiquitous to everyday life and successful development in particularly developing countries. What may have been regarded as science fiction a few decades ago are now taken for granted with smartphones, global information networks, and virtual reality. At the same time, societies, as we've just seen over the past couple of months, are becoming ever more dependent on digital technologies and infrastructure, banking, electrical grid management, health records and services, personal information and data, education services, and other government and state services all rely now heavily on digital databases. And the trend is even toward a wider use of digital technologies with a great deal of hype around artificial intelligence and the promise of what it can do in societies, including crime fighting. Around the world, one of the issues that has come straight in our faces is the issue of digital inequities, where we've seen in Trinidad, Tobago, and several other parts of the world that not everyone has access to Wi-Fi or digital networks as they should, which significantly impedes their ability to access services, including education. And the issue of a robust state digital communication ICT network, inclusive of some incarnations of a heavily subsidized one, is critical for particularly vulnerable groups in society. In developing countries with over 90% mobile coverage, like in Trinidad and Tobago, and even 50% of the population owning smart devices, more in Trinidad and Tobago, the research has shown that 20% penetration is necessary to reach critical mass, whereby vulnerable parts of the society have access to services, including education and government services, etc. We certainly have a significant penetration in Trinidad and Tobago, but the COVID-19 pandemic has underscored the shortcomings in education, the issue with finding and consolidating a robust database of population data for social grant intervention and delivery, information about grants, data collection, medical services, just to name a few. The pandemic has highlighted Trinidad and Tobago's need for this significant aspect of our digital infrastructure to be made robust and to be an imperative moving forward. In an important paper described called Digital Society 2017, there are several important questions every society must ask itself. How are public matters and public sphere and political processes and services changing the conditions created by digitization? What are the gains in freedom due to digitization? Does digitization threaten to bring about privatization of the public space if the state isn't proactive in providing a subsidized, robust network, particularly to rural communities? What opportunities does digitization offer for economic development and growth, especially in our contracted economy? Does it endanger social well-being? Do we have systems and legislation in place to protect groups? What are the implications of a digitized public sphere for political inclusion and participation? Is digitization dividing or fragmenting society, and are we contemplating these issues? Is it creating new forms of solidarity and national unity? And is digitization and a robust infrastructure leveling the playing field or widening inequalities? And how is government planning and policy enabling the creation of opportunities and equalizing the systems in the country? While it still tends to be regarded as something new, it's in fact already reached industrial production level around the world. And we in Trinidad and Tobago must, and I stress must, take cognizance of that. I know the government has iGov-TT, which has been able to be an interface between the public and delivering information, but it must go way further than that. The challenges for policymakers and society as a whole include the following, but are not limited to: an infrastructure that allows for global provision of global-level internet-based services and goods, better conditions for startups and the creation of incentives and capitalization and financing of them, an education campaign to train young people in IT and business skills for the digital economy, and how socially responsible is the population being prepared as digital services become more ubiquitous with everyday life. I think it's important for these questions to be answered in a country like Trinidad and Tobago, where we've come through the pandemic with flying colors in some aspects, but certainly the pandemic has shown that we have great shortcomings in other areas. So the question about government's plan and policy for a robust state digital communication network and ICT policy and plan for development is an imperative for our country moving forward. Thank you very much, Madam President.
Minister of Public Administration.
Thank you, Madam President. Madam President, the Government of the Republic of Trinidad and Tobago recognizes the role of information and communication technology in an increasingly connected and interdependent world that transcends geographical boundaries, economies, and sectors. Over the past 2 decades, ICT has contributed significantly to the emergence of new sectors, driven efficiency in governments and business operations, and it now constitutes essential building blocks to knowledge-based economies. As such, government views ICT as an indispensable tool in the achievement of its development objectives and outcomes. The National ICT Plan has identified promoting digital inclusion as one of the strategies to bridge the digital divide in Trinidad and Tobago by ensuring that all members of society have equal access to ICT, content, and services, with increasing opportunities to leverage ICT innovations to address national challenges. The communications and broadcasting landscape has enjoyed tremendous growth over the last years, with the number of telephone subscribers almost doubling from 1.246 million in 2005 to approximately 2.471 million in 2018, representing a ratio of almost 2 phones for every citizen. Similarly, internet household penetration currently stands at 82%, representing the number of households in Trinidad and Tobago that subscribe to a fixed internet service. The government continues to recognize the importance of countrywide availability of ICT, in particular access to broadband services, and has identified target penetration rates to be achieved over the next 2 to 3 years. The projects that we have implemented and are implementing to ensure systematic, orderly development and resilience of the country's ICT infrastructure, largely being pursued by TAT, include the following: establishments of standards to promote robustness of national communications infrastructure, development of technical standards for public fixed telecommunication networks. This project comprises the establishment of technical standards to promote resilience and redundancy for public wireless telecommunication networks and infrastructure that support such networks. These standards will also inform National Emergency Communication Plan being developed in conjunction with the Office of Disaster Preparedness. Modernization of the spectrum management framework is another measure being undertaken by TAT, and the third is assessment and forecasting of the country's international fiber connectivity and capacity, which will ensure the robustness and redundancy necessary for the country's international connectivity by improving the resilience of the inter-island fiber connectivity and establishing a second cable landing station. To facilitate connectivity, we have, among others, the TT Wi-Fi project, which is the establishment of countrywide wireless broadband internet networks. And this is currently being pursued by the Ministry of Public Admin as part of the National ICT Plan in alignment with Vision 2030. The project goals are to provide free, secure, wireless internet access across Trinidad and Tobago and to establish a nationwide public broadband wireless access service. This project seeks to establish a free island-wide public broadband wireless network in keeping with the ICT plan, and in so doing, the project is expected to meet the following goals: creation and deployment of a free island-wide public broadband wireless network and deployment of free public hotspots in public areas. This program is in process. With this in mind, the expected outcomes are as follows: increased utilization of the internet and interest in ICT so as to encourage activities in this sector, increased access to government information and easier access to services, greater participation in the digital economy and community, increased opportunities for education, training, skills development, and business. The policy framework of GOT provides for the initiation of the process for a free island-wide public broadband wireless network, starting with free public hotspots in public areas. This commitment was reiterated in 2016. Thus, the TT Wi-Fi initiative is aligned with GOT's vision of providing free and easy access to broadband internet in public spaces, providing connectivity to all users with a Wi-Fi-enabled device, including smartphones, laptops, and tablets. TT Wi-Fi was launched in July 29, 2016 to provide free broadband wireless service in selected popular public spaces in Trinidad and Tobago. It is to be noted that options for different public Wi-Fi delivery channels are being explored with a view to achieving digital access and inclusion, and therefore greater participation in the information society. TT Wi-Fi has been installed on 13 public transport buses. It allows citizens to access government websites and services, check their email, connect using preferred social media applications, keep in contact with friends and family, check the latest news. This is to be expanded by the Ministry of Public Administration in collaboration with the Ministry of Works and PTSC. The implementation team led by TAT and including Ministry of Public Admin and representatives from the service providers have completed site visits and are in the process of deploying 145 sites via the Universal Service Fund at the following locations: select transport hubs, public waiting areas and health facilities, and public spaces at libraries. The Ministry of Public Admin has engaged the services of iGov to manage and deploy TT Wi-Fi at first-tier public offices in various ministries. The implementation team has met and is currently conducting sites identification and assessments. Community-based ICT centers. Implementation of this initiative in ICT underserved areas across Trinidad and Tobago began in 2013. The aim of these centers was to establish a user-friendly, technology-enabled environment within communities, in addition to targeting traditionally underserved groups such as the physically challenged, the elderly, and at-risk youth. Communities are usually identified using the Digital Divide Survey, which is produced by TAT every 4 years. The ICT centers play a pivotal role in connecting and serving communities where telecommunication and ICT infrastructure is not yet widely available. The establishment and operation of the ICT centers is beneficial to communities as they lead to improvement in access, increased ICT literacy levels among citizens in underserved communities, improved computer and other vocational skills, improved training facilities and capability for basic ICT training, improved government communication, increased awareness of e-services and other GOT services, greater awareness of the benefits of technology and technology-based services, increased demand for services, the provision of voice and video conferencing facilities to staff, residents, and the business community, inclusion in the greater knowledge-based society, opportunities for increased revenue generation. Currently, the following 5 centers have been successfully operated in the following communities: Kumana, Guayagari, Marak, Penal, and Todd's Road. The centers offer the following free services to the public: computer and internet access via cyber cafe concept, wireless internet access for use with user-owned devices, ICT training including basic computer literacy, internet literacy, and productivity tools. We are in the process of expanding this, and it was the intention to add 10 more centers during the course of 2020. COVID has put pause to that, but we are diligently pursuing it.
Minister, I remind you, you have 1 more minute.
Thank you, Madam President. TT Connect service centers are also part of the program that we have launched to increase and improve connectivity throughout Trinidad and Tobago. Madam President, what I would like to add before I close is that all of these programs were in place pre-COVID and pre the lessons learned from COVID. The Roadmap Committee has recognized the significance of ICT to Trinidad and Tobago given the COVID period and what we expect to be post-COVID, and has focused and continues to focus significantly on this area, and we expect that this national ICT program will be significantly developed, enhanced, and advanced as a result of the recommendations coming out of that committee. I thank you, Madam President.
Honourable Senators, the question is that this Senate do now adjourn, sine die. Those in favour say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned, sine die.